substances, not all narcotics. Cocaine seems quaint now, but it is very addictive and involves effect of your mental health. All right, so you got a lot going on. You got a case pending, you've got counsel in another county, you're connected to the VA, you've got further treatment planned, but this probation was a dud. We didn't really accomplish much of anything, particularly regarding domestic violence treatment. In light of his admission, Mr. Huff, what's your recommendation?
Well, this is a very difficult case to make a recommendation on for a couple of matters that have been highlighted already. First and foremost, I mean, some of what he's going through obviously stems from his service and the post-traumatic stress that he suffers from as a result of it. So I think there's a certain amount of empathy that ought to be extended given the context of his situation. But we also have to consider the fact that there's a victim in this case. And I do wonder if the victim was sitting here in the courtroom, what she would say. What she would say needs to happen in order to get his attention, because obviously this was someone that he had an intimate relationship with, and probably somebody who they both cared about for a while. But the bad stuff that was going on was enough to make a permanent split. I think that this was probably always about mental health and substance abuse. That's probably why the split happened. Maybe I'm wrong, but again, we don't know a whole lot when I don't have communication with a probationer. I'm a little bit concerned, again, there's a gap where I have to fill in the blanks there and wonder what happened from when he was released from treatment. And then he calls me the day before the probation violation hearing. I am encouraged that he's willing to admit that he's responsible for these actions and that he wants to, I guess, curb this sort of behavior from his life. But at the same time, there needs to be some sort of ramification for his actions. I don't want to deprive him of going to the post-traumatic stress disorder program at VA in Battle Creek. So first and foremost, I would say if the judges or if the court's inclined to impose a jail sanction, that it'd be less than the amount of days that it would take in order for him to go to that program, because I don't want to see the court, obviously anything that happens, he's earned. However, I don't want to see us get back in the way and have him go down again. I think I use the analogy, I don't like to hammer people who are back on the upswing. But this is a very difficult situation. I don't think his history is conducive with the probation. I don't think the probation should be continued. There's a non-public status attached with this, I believe, as well. I don't think that you can go out and get a new charge, abscond, and have several positive tests, several missed tests, and still have a probation go through successfully. I just don't believe that that is the spirit of what probation is designed for. So I think some jail is appropriate. I don't think a lot of jail is necessary to get Mr. Andrews' attention. I think we have his attention right now, but I would give my input there. And then I also wanted to make one note too about the request for release of information that I provided the court with. I showed Mr. Andrews' counsel the exact same document ahead of time. A little bit concerned because it's kind of like a half authorized information release. It shows that they can give us discharge dates and acceptance dates, but they can't talk to us about what sort of treatment they're doing or any intimate details. I don't need to know ever with any of my clients what they're talking about, the topics. But the second box that's checked on there just basically says, like, unless it has to do with drug abuse counseling treatment, I don't want any information given to the courts. And so I'm sure, if I talk to him, he'd probably be like, oh yeah, I want to check that box, or I'll sign something different. But that's why I provided the court with that. I just wanted to make that clear.
All right, we'll hear from the prosecutor and then we'll hear from Mr. Bush and the defendant. Ms. Camfield, do you have any input on this?
Your Honor, mental health concerns are always difficult for the court and probation agents to deal with when they may be an explanation for assaultive behavior, but certainly not an excuse for it. In this particular instance, as I'm reading the report, it indicates that she may have had a broken nose from being headbutted in the face by this defendant. Children were going to be coming over later. He just failed to do anything that he was supposed to do. He's aware of that. He's indicated to the court why that occurred, and did subsequently get himself into treatment programs which were appropriate. But again, we have him having committed an offense and being put on probation to rehabilitate from it. And while he is getting mental health treatment with the VA, it most certainly is not the domestic violence therapeutic program that this court ordered. And I'm sure that that particular instance may not even be addressed to the extent that it would have had he complied with his probation here. Whether or not they're still together and whether or not that was a toxic relationship is not as important as how do we rehabilitate him not to be violent with another partner in the future, and also give a consequence for what he did to his previous partner. It was a pretty serious assault. He's failed to comply with this court's order. So I do agree with Mr. Huff that jail is appropriate. Under circumstances of this, if there weren't a mental health component and he hadn't availed himself of the VA services over this past summer, I would have recommended the maximum time in jail for the offense, in addition to the revocation of the deferral program and the entry of the conviction. At this point, I'll leave the jail to the court's discretion, understanding that he's got a program waiting for him, but also knowing that he needs to have a severe consequence for what he did to this victim, as well as just ignoring this court's orders for the duration that he did.
All right, let's talk about that. This probation violation hearing with Judge Middleton really showed how layered a courtroom moment can be when mental health, accountability, and public safety all overlap. The defendant, Mr. Andrews, walked in with a complicated story, service-connected trauma, ongoing treatment with the VA, and a trail of missed opportunities on probation. Judge Middleton's demeanor stayed steady and pragmatic. You could tell he was weighing compassion for a veteran dealing with PTSD against the responsibility of ensuring probation isn't treated like a revolving door. The probation officer's testimony struck that same balance, noting that while Andrews had finally engaged in treatment, the road to get there was littered with missed tests, absconding, and virtually no progress in the court-ordered domestic violence program. His assessment was candid. Probation had been a dud, and while some empathy was warranted, so were consequences. The prosecutor followed with equally thoughtful remarks, highlighting that the underlying offense wasn't minor, involved a serious altercation and harm to someone Andrews had once been close to. Her point landed clearly. Mental health issues can explain behavior, but they can't excuse it, and ignoring court orders can't just slide by. What I appreciated was that both sides resisted the extremes. Nobody was calling for the book to be thrown at him without consideration of his treatment needs, but neither were they willing to pretend that probation compliance had been acceptable. The consensus: jail time was appropriate, but calibrated enough to underscore accountability without derailing the VA program he has waiting for him. From the defense table, Andrews himself admitted responsibility, which at least gave the sense he wasn't just deflecting or minimizing. His counsel emphasized the importance of the PTSD program and urged the court to prioritize treatment over punishment. Judge Middleton seemed receptive, but made it clear that probation isn't designed to be endlessly forgiving. He listened, let each party make their case, and seemed intent on crafting a sentence that recognized both rehabilitation and deterrence. The overall courtroom atmosphere was serious but not tense. No outbursts, no grandstanding, just a sober discussion about how to balance justice and support in a tricky case. If anything, the most striking element was how collaborative it felt. Everyone agreed Andrews had issues to work through, but nobody wanted to let him skate by without consequence. That's the justice system at its best, recognizing the human being in front of the bench, while still safeguarding the principles of accountability and rehabilitation. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,